everyone, and welcome to Daily Newspaper Analysis, which is brought to you by LawSikho. So today we will discuss two articles. Both are from the Hindu newspaper. The first article is titled as "The Bar on Criticism That Muzzles the Advocate." So this article talks about the bar or the limitation that the Bar Council is trying to put up on the freedom of speech and expression of the advocates. So what is this proposal, and what way can it hamper the freedom of speech of the advocates has been discussed here. The second article is titled as Undead Section. This talks about Section 66A of the IT Act, which is the Information and Technology Act, which was struck down by the Shreya Singhal case, but yet recently has been seen that this has been invoked by the police personnel. So what is actually happening will be discussed here. So this newspaper analysis is presented by me. My name is Sheva Khan. I am a law graduate and had completed my law degree in the year 2019 with a gold medal in my batch. Here at LawSikho, I'm working as the manager for current affairs vertical. And if you wish to connect with me, you can find me on my Twitter as well as LinkedIn handles. The links to both are available in the description box below. Here is an important announcement for all of you that from today itself, that is 10th to 12th of July, LawSikho is organizing an absolutely free 3-day bootcamp on how to crack Indian judiciary exams. So if you have any confusions or any queries regarding your preparation for judiciary exams, you can definitely enroll yourself into it. The registration is absolutely free and you can find the link in the description box below. Let's see what is the multiple choice question from yesterday's discussion. Bringing back a fugitive from one country to the home country is known as. Your options are arbitration, conciliation, extradition, or mediation. If you know the answer, you can put it down in the comment section below. This is a descriptive question of the day. What is the significance of the Shreya Singhal case when it comes to freedom of speech and expression? You can write down this answer in a word limit of 250 to maximum 300 words. So if you wish to download the PDF of these slides or want to avail other study materials like the notes for various topics or the newsletters, daily quizzes, etc., you can enroll yourself in the Telegram channel of LawSikho. You can find the link in the description box or directly can scan this QR code that you can see on your screens. Also, do not forget to follow us on our Instagram channels for Judiciary, CLAT preparation, as well as UGC Net if you're preparing for any of these exams. So let's get started with the first article of the day, which talks about the bar on criticism by lawyers. So the recent amendments in the Bar Council of India rules render advocates liable for disciplinary action for making disparaging statements about a court, judge, BCI, or even the state bar or its members. So basically here, a limitation has been brought on the power of criticism that was earlier given to the advocates. And now any statements that they are drawing, be it about the court, a judge, the Bar Council of India, or even the state bar or its members, will be under a complete check. And that is why they would be liable for any kind of disciplinary action if these statements are found to be foul or they are considered to be inappropriate by the stakeholders. So the consequences of this is that it includes suspension and disbarment. So if at all we're talking about that, what kind of disciplinary action can be taken against the advocates? So either they can be suspended or even they can be disbarred, or their license can be taken away by the bar. So the BCI has kept rules in abeyance pending review by a committee comprising senior advocate and members of bar. So moving further, let's understand the background of this entire issue. So during the time of March 2020, 22 senior advocates addressed an open letter urging the Supreme Court to intervene in the migrant crisis. Now, as we know that it was the time of March 2020 itself when all India nationwide lockdown was proclaimed, wherein the greatest brunt was faced by the migrant workers because obviously they were serving or working in states or cities other than their hometowns. And because of the lockdown, they were not able to move back to their native villages or towns. In such a situation, we also know that the Supreme Court was the one that had taken the suo motu cognizance. And when we talk about the suo motu cognizance, we mean that a cognizance or an attention that is taken by its own. So this is the exactly same time what we are discussing about here is of March 2020, wherein 22 senior advocates had addressed the court through an open letter urging the Supreme Court to intervene in this entire issue of the migrant crisis. So the Bar Council of India characterized the criticism as a sustained and synchronized attack on the Supreme Court. So this open letter by the senior advocates was taken by the Bar Council of India as a criticism of the Supreme Court, and it said that this actually disgruntled the members of the bar and some unhappy and disappointed former judges as well. So here also there was an article in the Live Law which criticized the BCI chairman Manan Kumar Mishra, which questioned his open allegiance to the BJP. So the Bar Council of India condemned author for scandal mongering and vilification and resolved to take action. So here we can see that there is a continuous power tussle which is going on between the advocates, the BCI, the Supreme Court, and even the other stakeholders that are in the same field. And that is why probably the bar has come on up with this proposal to condemn or to limit the power of the advocates to criticize the court, the system, or the judiciary, or the bar itself. Definitely, this is not something which can be celebrated on the parts of the lawyers, at least, because this definitely puts down their power to speak openly and to be, what they are or what they feel. And we can understand the situation that if at all the advocates in the country also would not be given the freedom of speech and expression, then how can we really expect the justice to be delivered by the courts? So this article also talks about some way forward in this direction, and it says that this is an opportunity for the Supreme Court to prevent a further assault on free speech by rejecting the amendment. So here it says that the Supreme Court can take this opportunity and can directly reject this amendment which has been proposed by the Bar Council of India, and can thus upheld and put forward the freedom of speech and expression, which has been endowed as a fundamental right under Article 19(1)(a) of the Indian Constitution to every person, be it an advocate or a general citizen as well. Also, the amendment leaves little scope for healthy criticism. Now, again, when we talk about defamation, so one of the the grounds, or the grounds for defense in the defamation also stands to be of the fair criticism. So if at all a person is criticizing something or someone which is on fair grounds, or it is based on truth, or basically it is an opinion which is fair and not demeaning, or it is not created with malice, so such is things considered to be as a healthy criticism, and it is considered that healthy criticism is very important for critical growth of any of the sections of the society. And if at all we take away this power of healthy criticism from the advocates, then definitely we'll put down this entire thing, and we will completely think the advocates to be complete puppets of law, which definitely should not be the case. So even if the disciplinary proceedings do not result in serious consequences, it will surely affect the careers of the advocates and have a chilling effect on the entire law as a segment as well. With this, let's discuss the second article of the day, which talks about invoking Invalid Section 66A. So the Supreme Court has been informed recently that for the second time in the 2 years, that the Section 66A of the Information and Technology Act, which all of us know was struck down as unconstitutional 6 years ago through Shreya Singhal versus Union of India case, is still being invoked by the police. Now, I know it would sound a lot too bizarre or a lot too difficult to digest that even after a provision of the law, which was considered or which was struck down as being unconstitutional, so how is it possible that it is still brought under use, or it is still being used by the police personnel? But unfortunately and surprisingly, that is the case that we are seeing currently. So if we talk about the Section 66A and its constitutionality, so this section made the messages deemed by the police to be offensive or menacing to anyone, or those that causes annoyance, as a criminal offense. So what would happen was that, for example, I being an individual, I used to put a message or any kind of status on my any social media platform, be it Twitter, Facebook, etc. Because keeping in mind 6 years ago, Twitter and Facebook were the two most important social media platforms. So if at all, but considering any of the social media platforms, if any message or any status, any point made by an individual is considered by the police, now who here is the judging authority? The police authority. All right. So here, if those messages or statuses, they are considered to be any kind of offensive, menacing, or annoyance by the police, so they would be termed as a criminal offense. So just putting up that message or status would be a criminal offense for me, and thus these were sent if these were sent through computer or computer source, and this even prescribed a prison term of up to 3 years on conviction. So this definitely can be seen as a clear violation of the freedom of speech and expression, because here also, if at all I have to say something about whatever I feel, or I have to go through a fair or healthy criticism, and that thing is not liked by the police itself, so then I would be the one who would be committing a criminal offense according to this section. And thus the Supreme Court brought it into its notice, and it struck down section 66A of the Information and Technology Act 2000. And in the Shreya Singhal case in 2015, it ruled that the provision is vague and violated the freedom of free speech. Then in 2019, the Supreme Court was informed that the invalidated provision, this, the 66A, is being used still by the police to register cases based on complaints. So surprisingly, that the police definitely should know, or it must have known, that this provision is no more a part of that act, and thus it is unconstitutional in its nature, and thus it cannot be invoked or it cannot be used by the police. But still, there were cases that came to the notice of the Supreme Court in 2019 that the police was still using this section to register cases based on various complaints. So the police headquarters and prosecutors have not disseminated the effect of the court ruling among the officers. And definitely here again, an important thing comes to our mind, that it should be made sure that if at all any judgment or any kind of ruling comes out from any court, be it the High Courts, the Supreme Court, or be it any court in the hierarchy, so the people on whom the effect of this particular ruling has to fall upon, they should definitely be intimated about it. Now, not unless you're aware about the legal status or the law what is prevailing in the country, definitely it is very difficult to expect that a person would act legally as well. So here a clear case is being seen that many police officers were not even informed. They are not even aware of the fact that section 66A is no more constitutional, and it has been completely struck down by the Supreme Court. And that is why it is important that the police headquarters and the prosecutors have this information disseminated regarding the rulings of the court amongst the officers. So if we talk about the invoking invalid provisions, so section 66A, as per the PUCL, 745 cases are still pending in the district courts in 11 states regarding section 66A, and instances of the section being invoked deliberately as a tool of harassment have also been seen. Again, section 500 of the IPC, which talks about the punishment for the defamation. So the Supreme Court ruled that defamation can be pursued only by way of private complaints, and there can be no FIR whatsoever in the other cases. And even then, the UP police booked a journalist for defamation under section 500 for the defamation of police itself, though it was not even a private cause as such. So definitely the percolation of the rulings of the courts are very, very important to make sure that the rule is not only given away by the court, but it can actually be implemented and executed in the real practical sense. So this was all for the day. We hope it was a good session for you. Thank you so much for listening to us. If you liked it, do give it a thumbs up and subscribe to our channels for never missing an update. Thank you so much.